Hi, my name is Arati Ganeshan and I'm a journalist at MediaNama. I'm delighted to welcome you all to the research presentations for the 2021-2022 cohort of the Meta India Tech Scholars. Meta launched the program to provide a research and mentorship platform to law students who are keen to engage on contemporary questions of technology, law, and policy. The law firm Shardul Amarchand Mangaldas & Co. is supporting the program as a knowledge partner. Through this series, the scholars will show us how specific policy choices in the technology sector influence and impact India's tryst with the internet. Today, we have Supriya Shekher with us. Supriya is a fifth-year student of the BA LLB program at the National Law University, Delhi. She takes a keen interest in issues of technology, law, and policy, particularly the gendered impact of data governance and the role and potential of antitrust in giving us back an open, free, and decentralized internet. In her spare time, she can be found reading literary or speculative fiction or taking long walks around campus with her earphones on. I'm delighted to have you here, Supriya, and I look forward to hearing about how you document antitrust law and privacy concerns in India.
Hi, Natasha, Aarti. Thank you so much for the introduction. So as introduced by her, I'm a fifth year law student at NLU Delhi, and I'll just share my screen to get started with the presentation. Yes. So, hello everyone. I was a Facebook India tech scholar for a period of 9 months from September 2021 to June 2022 and was mentored by the Carnegie Endowment of International Peace. My research paper is on the theme of data governance and on the topic the face off between antitrust and data privacy laws in India, a case for rethinking privacy. Uh, Data governance and the role of antitrust law and policy when it comes to furthering our material well-being are two of my primary interests, and this research was sort of my attempt to wed them together. Through my research, I've endeavored to question certain assumptions that we have about how privacy governance must look like, what are the ways and forms in which it must take, and that any attempts to preserve privacy must always be good. Um, I'll just get started. Yes. In India as well as internationally, it is being increasingly debated whether data privacy is also an antitrust issue or if it should be singularly governed under a separate data privacy law. The debate, as many of you would recall, caught the attention of lawyers, scholars, academicians back in India in 2020 when the CCI took suo motu cognizance of WhatsApp's updated privacy policy. Existing literature on the issue can be divided into two broad categories based on the kind of approach it advocates for in this regard. The first is the integrationist approach, which argues for subsumation of data privacy within the antitrust framework as a non-price element of quality, and the separatist approach, which argues for a clear delineation between antitrust and data privacy, with the two regimes being mutually exclusive. However, I seek to argue that irrespective of the legal regimes it is governed by, in certain cases we shall witness the inevitable clash of antitrust and data privacy laws. Consequently, the scope of the debate has to be broadened, and we need to grapple with the question of not just under which law must privacy be regulated, but also, firstly, what recourse must the law take when preservation of privacy stands squarely at odds with the promotion of competition, and secondly, what is the ultimate goal of privacy regulation and governance? I shall now briefly discuss the three chief areas of tension between antitrust and privacy in digital markets. The first of such areas is mandatory data sharing remedies. The first site of conflict is when mandatory data sharing is granted as an antitrust remedy to check the dominance of big platforms vis-a-vis smaller firms and new entrants in the digital markets. And I argue that the genesis of this conflict is the proprietarian conception of data espoused by data privacy laws, such as European Union's GDPR and also India's proposed data protection law. They view data as the personal property of the data principal or the data subject in question. Now, such laws present a proprietarian conception of personal data primarily because of three features. Firstly is the provision of data entitlements, as per which even though data is seen as a kind of commodity which is capable of changing hands, the data subject must always retain the ultimate entitlement to this property. Secondly, rights of data subjects subsist even after data transfers and bind third parties as well. We see reflection of these in provisions in almost all major data privacy laws. And thirdly, the nature of remedies offered, which are grounded in property rules. Now, when such is the nature of rights vested with data subjects over their personal data, it's uninhibited exchange, which is what mandatory data sharing would require. A company would have to share all the data that they have, personal data on its users, with other companies to facilitate free competition. Now, that kind of an uninhibited exchange would be impermissible, and it would arguably constitute an assault on the personhood and dignity of the data principles itself, owing to the fact that one's property is considered an extension of their personhood and also the chief enabler of individual freedom in a free market economy. The second site of conflict is the privatization of privacy governance. Now, this emerges when private enterprises in digital markets roll out business strategies which have the stated goal of enhancing user privacy, but also lead to a phenomenon that I have termed as privatization of privacy governance, wherein an attempt to enhance user privacy may amount to a competition distorting commercial strategy in digital markets. Now, for the purposes of my research, I studied antitrust investigations launched against Apple's app tracking transparency policy in France and Google's privacy sandbox proposals in the UK, and came to the following three conclusions. Firstly, in both these cases, there was privacy invocation in behalf of third parties being made by Apple and Google, the third parties being their users, to renegotiate their relationship with advertisers using third-party cookies in case of Google and app developers in case of Apple, respectively. Secondly, these can lead to their emergence as de facto regulators and standard setters, since they require stakeholders to go above and beyond applicable data privacy laws. And thirdly, in Google's case especially, the privacy sandbox vision may ultimately lead to decreased privacy innovation in digital markets, owing to its negative impact on development of non-Google technologies. These cases point to the concerning trend of the view of privacy espoused by Google and Apple, private companies prevailing in the web advertising ecosystem and the wider framework of digital markets, effectively privatizing privacy governance. The third area of conflict is when privacy must be compromised to enhance functionality. Now, more data arguably enables suppliers of services in digital markets to provide more features, more functions, and better accessibility to users. This leads to enhanced consumer welfare, which is a central goal of competition policy. However, this also spells doom for user privacy. To then arrive at an answer for how we must think about privacy and consequently privacy governance, I built on Professor Daniel J. Solovy's theory of privacy and apply it to digital markets. His theory establishes four important things for the purposes of our research. Firstly, he argues that privacy is not an inherent property of things, but instead is normatively constructed. Secondly, our normative understanding of privacy must first engage with the very specific problems which trigger the desire for privacy, both at an individual and societal level, instead of any abstract ideas or universalized principles which we might have about this concept. Thirdly, he argues for a pluralistic, inclusive, and bottoms-up approach to privacy with a set of privacy protections against a cluster of harms. So he essentially advocates for a harm-centric conception of privacy. You identify a plurality of things falling within the broad metric of privacy and then choose the law best suited to address those specific harms. And fourthly, he argues for a balancing act to be carried out in case there is a conflict between privacy and countervailing interests. And importantly, he cautions against always assigning a negative value to said countervailing interests. So for instance, in case there is a conflict between public interest, larger public interest, and privacy, the goal of preserving privacy must not always be given priority. Other interests must also be given their due weightage, is what he effectively argues. So he comes to refer to privacy as a shorthand for a cluster of problems which need to be solved. Applying this theory to digital markets, my research comes to three conclusions. Firstly, there is a need to disentangle this concept from personhood, the body, and consequently individual dignity. Surely these are important aspects of privacy, but these are not what privacy is entirely. It is much more than that. Secondly, we have to conceptualize privacy more expansively to address multiple harms caused by use and manipulation of information flow in a digitized world. And thirdly, we need to build a privacy framework expansive enough to address power disparities between people and companies and collective societal harms which emerge from information technologies. So, the conclusion that emerges is that in digital markets, power disparities generated among stakeholders in the digital ecosystem owing to privacy exploitation is a legitimate harm which the law must seek to address. Coming to how privacy is understood in the Indian legal imagination, such a nuanced and broad understanding of privacy has been absent in Indian jurisprudence, which is arguably still in a nascent stage when it comes to privacy governance. It is limited in scope in as much as various facets of privacy, such as autonomy and dignity, are recognized, but it does not go beyond that. Courts till date have not engaged with the power asymmetry that triggers and that enables an indiscriminate assault on privacy, especially in an online context. And it is precisely this power asymmetry that further leads to loss of dignity and decisional autonomy. Coming to the Data Protection Bill 2021, I understand that there has been now a new iteration of the bill. However, the arguments which were made at the time of me writing this research paper with regards to the DP Bill 2021 stand true even now with the new iteration of the bill. Now, the bill conceptualizes privacy in terms of a fiduciary relationship between data principals and data fiduciaries. So, a duty of care is imposed on data fiduciaries through the provisions pertaining to fair and reasonable processing. Now, this obligation to fairly and reasonably process data goes above and beyond the obligation to consensually process data. So, essentially, even if data fiduciaries have the consent of data principals to process their data, they must also undertake a second level analysis to ensure that the processing that they're doing is fair and is reasonable. Now, while this may seem ideal, as there is no dearth of privacy literature on how severely deficient the consent and notice framework is in the digital context, a fiduciary framing too is deficient for four primary reasons. Firstly, it is too individuated a response to privacy eroding structural power wielded by online platforms. Information asymmetry and consequent vulnerability, dependence, and abuse are primary threats to privacy online. Secondly, it could trigger a conflict between duty of online platforms towards their shareholders, which would obligate them to maximize revenues, because we have to remember these are companies at the end of the day with a profit motive, and their fiduciary responsibility towards data subjects, which may require significant and likely profit affecting changes in their existing business models which survive on surveillance advertising. Thirdly, simply accepting the fact of power imbalance between users and online platforms would be a cosmetic addressal of the constructed character of such an inorganic imbalance triggered by market dominance. Fiduciary framing just accepts that there's a power imbalance between companies and their users without taking the analysis a level deeper and analyzing why is it so. Fourthly and finally, this model lacks teeth and is severely myopic in the face of other expansive and structural visions of privacy regulation, which are better cognizant of the systemic characteristics of digital platforms, which create conditions for generation of privacy harms. Therefore, I make four important recommendations towards the end of my research to deal with this issue. Firstly, taking cue from Professor Solove's theory, the law does not need to grapple with the question of what constitutes privacy and an exhaustive standalone privacy law to regulate it. The concern must only be to identify definite privacy harms and select a law best suited to address those harms. Secondly, in case of mandatory data sharing, Professor Solove's argument for a balancing act to be carried out in case of conflict between privacy and countervailing interests can be utilized. Therefore, the law must not unduly prioritize antitrust concerns over privacy concerns, but carry out a balancing act on a case-by-case basis to ensure that the mandates of both legal regimes are respected. So you can explore solutions like taking explicit consent of individuals before sharing, or requiring them to opt in while when such mandatory data sharing takes place instead of the standard opt out model. Thirdly, privatization of privacy governance can entrench market dominance and enable entities in digital markets to determine not just how much privacy they will offer to their users. And we need to remember that users at the end of the day not only have no effective bargaining power with these big companies, but also no real option to leave in the absence of alternatives. Doing so would essentially amount to their complete exclusion from the internet economy. But also, these platforms come to determine how privacy will be regulated. So privacy is effectively wielded as a tool of power to shape not only its present state but also its future evolution in terms of who gets to innovate on privacy and how. And this must be seriously scrutinized, because regulatory mandates should come not from private participants but from regulators, as private participants are should ideally be operating on a level playing field. And lastly, individual centric responses, such as those espoused by this fiduciary framing of data governance, should be discarded, and antitrust law must be leveraged to structurally overhaul digital markets. It must be used to dismantle existing power hierarchies in digital markets which monopolize personal data and privacy governance itself. It must seriously engage with such models of personal data governance being put forward, which address the very structural basis, the institutional sociology, and the incentive models of digital markets, such as adoption of data as semi-commons approach, data trust, etc. So this was my presentation, and I hope it was helpful to all those who are watching.
So thank you so much for your presentation. I think it's fascinating the way you kind of juxtapose these two things, and it's perhaps one of the biggest issues concerning competition regulators across the world, including in India as well. And it's work that we've done a lot of. We've done a lot of reporting about it at MediaNama as well. I just had a foundational question, and I'm coming at this as someone who's assuming that companies work really hard to kind of achieve the outcomes that they do, right? Like whether it's a small company, a big company, you're developing specific R&D models, specific business models, you have specific products. So I'm just trying to essentially understand like why data sharing is considered an effective tool to address antitrust. Because I also see the flip side where it's like, this is my information that I've spent years, developing, being sort of shared with someone else. The copyright issues also come up, like you rightly mentioned, privacy issues come up. So why is this seen as a desirable alternative, a desirable method, as opposed to any other alternative that might actually perhaps protect the structural integrity of what you've spent years trying to build? So just your thoughts on that.
Yeah, thanks for that question, Aarti. So it is true that companies collect data and a lot of their own efforts go towards collection of such data. But firstly, I would argue that it's sort of based, the dominance that the firms come to enjoy based on the data that they acquire is based on the finders keepers logic and the first movers advantage, wherein the companies who started out earlier now have more data because they were able to collect it first, to the exclusion of anyone who would want to enter the market now, which raises a significant barrier to entry for new firms. So of course that raises competition issues, that raises abuse of dominance issues, and this is a concern that has been cropping up in various ongoing antitrust investigations. For example, the state of Texas recently sued Google over this. So yes, so firstly, to answer your question of why it must be done, is firstly that while the companies were the first to acquire such data, we cannot effectively say that they've come to exercise a right on it. It is, at the end of the day, the data of the data principles. And there is a lot of literature coming up on how we can conceptualize data as labor by these data principles. And the companies are essentially monetizing this data without adequately compensating those data principles whose labor this data is, for all the benefits that they come, for all the commercial benefits that they come to enjoy off of it. Secondly, to deal with concerns such as the specific R&D models they develop, the specific intellectual property efforts that they put towards the generation of this data, The emerging literature on this talks of data as a semi-commons approach. This approach was recently argued for in a paper by the Internet Governance Initiative. And they essentially said that the first level of data that you acquire, the raw material of that data, should be openly accessible to everyone. And the second level of innovation that you do on the data should essentially remain your own property. So essentially, data that is the raw material should be open and accessible to everyone, because no efforts being put into making any sense out of it. And the second level of innovation that firms do on that data should remain their own property. So data is common, but it's not, it's treated as a global commons, but not at all levels of innovation. So I think that sort of also addresses this.
I mean, that sort of brings to mind many government proposals in India. So also like advocating for these massive data sets that everyone can use, these large databases that people can use to
Right.
the digital economy and sort of boost innovation and address these competition issues. I think what I like the most about what you said is that we can potentially be compensated for our data being mined, which hopefully will come to fruition at some point. I think my second and final question here is you'd spoken about this kind of capture by private companies of not just surveillance, which has led to these antitrust and sort of privacy issues, but also the technology that's required to address surveillance, the privacy in protecting one, whether it's Sandbox or ATT by Apple. Um, I just want to be the devil's advocate here. Who else is supposed to kind of address these issues on scale, right? When I think of it intuitively, I understand this might be naive, but these are the companies that have started the problem in many ways. This is a huge, the scale is sort of unimaginable. It spans multiple countries, billions of people. Who else is better positioned to kind of develop this technology? I'd be interested to know on that front. And also, you'd mentioned regulatory steps should sort of be the norm instead of private capture. In that case, what are the regulatory steps that we should be looking at?
Right. So, as I've argued in my paper, that privacy governance has effectively come to be privatized because private companies and dominant private companies are now shaping the narrative on, sort of what's good for preserving our privacy, how must we go about it, and it's expected to be accepted without any questions by the rest of us. But it's important to understand here that in privacy governance, the stakeholders, not just private companies, sure, they are the ones, as you said, who created the problem, and they are the ones who could arguably have a lot of resources and technical know-how at their disposal to deal with these issues. But we need not look far enough for alternate visions and alternate ways in which this might take place. Internet governance has essentially come about to be a multi-stakeholder approach. We have supranational organizations like ICANN or IANA working in collaboration with nation states, and also international organizations like the OECD or the UN coming up with guidelines that serve as sort of, all these have come together to serve as sort of soft law measures as to how internet governance now takes place. And a similar model needs to be replicated for privacy governance as well, because while private companies were the ones who started this problem and have resources at their disposal, they come to this issue with one, I would argue, one perspective in hand, that is how they can balance it with their profit earning motives. And we can't really blame them for it. They are companies at the end of the day. They do operate with a profit motive, and that's what their incentive to innovate is as well, so we can't stifle that motive as well. But when governments approach it, they come with sort of an approach to, preserve their national sovereignty and also to some extent user rights. When users come to the table, they come through civil society organizations. They come at it from a different perspective with regards to how they can safeguard their rights, how they can ensure that they get maximum quality of services as well as maximum benefits out of the services that are being provided. So it essentially has to become a multi-stakeholder resource. And I would argue that even nation states also have a lot of resources at their disposal in terms of the monopoly they enjoy over enforcement of laws and such, which is also an important thing which needs to be here, that companies don't have. So everyone sort of comes with different positions from different perspectives, and we need to incorporate all of that.
All right. And just a bonus question, where do you see India heading? I mean, you've talked about this balance. Where do you see India heading? Are we more kind of state heavy? Are we letting platforms do what they want? How would you view that?
While initially we were sort of letting platforms do that. In the last few years, I think we're moving towards the state sort of stepping in and realizing, hey, we need to take the reins in our own hands. I don't know whether it's getting too weighed in the favor of the state here or not. I think it's too early to say that because the law is still developing. We come up with new iterations of the bill every other day, and here's hoping that we finally settle on one version. We at least have some data privacy law to speak of before we go on improving it. But in India, I think there are concerns of data localization and data sovereignty that have come to occupy a lot of importance in the privacy antitrust debate. And we're also seeing the state sort of now roping in the CCI to rein in big tech companies. So the attack is sort of coming from all fronts. We see IT rules which are mandating very tight regulation and very tight compliance requirements for companies. We're also seeing the state letting its market regulator, the CCI, step in and rein in big tech companies. So I think sort of India has now taken a very proactive approach towards these companies, and hopefully we have some positive developments on it in the future as well.
Absolutely. Well, thank you so much, Supriya, for taking out the time to present your research. If you'd like to read more about Supriya's work or watch this video back or watch the other scholars in action, please do visit MediaNama.com. We'll have all of this under one banner so that you can go through what India's youngest tech policy scholars are working on right now. Thanks a bunch, Supriya. Bye-bye.
Thank you so much. Bye.